Hello, my name is Lisa Gonzalez, and this is my presentation on legal environments of business. The case I chose is Rosenberg versus Google. In this case, the plaintiff, Rosenberg, alleges that the defendant, Google, is at fault for providing negligent walking directions, which resulted in her being struck by a passing vehicle. Google created its Google Map application in January of 2005. About 3 years later, in September of 2008, Google released its mobile app version. The version was accessible by mobile phone. However, the computer version and the mobile version had some differences. The mobile version lacked the safety warnings that the computer version did provide. The plaintiff claims that the defendant should be held responsible as the information it lacked resulted in her being struck by a vehicle, and those safety warnings could have prevented that. The route that the defendant, Google, provided to the plaintiff was a rural highway, not suitable for pedestrians. It lacked sidewalks. As a result, the plaintiff actually tried crossing a 4-lane highway, and a passing vehicle struck her. The plaintiff has also included the third party in her lawsuit. The question now is whether the defendant is truly at fault for the tragic events that unfolded that night. The plaintiff alleges allegations include general negligence, failure to warn, strict liability with an emphasis on defective design, and strict liability with an emphasis on failure to warn. Google immediately contested the allegations 3 and 4 under the product liability theory, and after review, the court reviewed Google's request and agreed to the motion to dismiss claims 3 and 4. So now the plaintiff has the 2 remaining allegations: general negligence and failure to warn. The plaintiff feels the defendant should have practiced suitable care by providing appropriate and safe walking directions. She also feels that the defendant should have proper warning and detailed the dangers that the defendant could have encountered. Rosenberg, the plaintiff, makes it clear that Google, the defendant, set the whole motion of events into motion with pure negligence. The defendant argues that legally they don't owe the plaintiff a duty to care. There were no binding agreements between the 2 parties, and they share no relationship that requires anything from one another. The motion that the defendant provided the information that the defendant provided was strictly public and made for all to use at any given time. The defendant also states that the plaintiff is to be held responsible to some degree, as she herself lacked and breached her own duty of care when avoiding common sense and willfully crossing a 4-lane highway and unfortunately being struck by a passing vehicle. The defendant continues also arguing that had it not been for the defendant breaching the law, she could have avoided this by not violating Utah Penal Code 41-6A-103, jaywalking, which contributed to being struck by the vehicle. They continue by stating that they should not also be held responsible for a third party's actions, the motorist himself. The defendant could not protect the plaintiff against negligence from a third party. So with this being presented to the jury, it was found that the defendant is not responsible for the injuries that the plaintiff suffered. Google's motion to dismiss is granted. It is foreseeable that some harm may occur. The likelihood of that harm is relatively low if the person utilizing the service is utilizing it with a degree of common sense. This is a huge win for the defendant. Had this gone in a different direction, no pun intended, the overwhelming effects could be really, really detrimental to Google and companies alike. They could, in reality, be held responsible for providing disclaimers and warnings and still yet hold a sense of responsibility to a degree of, injury that could occur. And this could flood the court systems with multiple litigations. And the lack of the user using common sense is just a contributing factor. So in my opinion, I truly think that Google came out where they should have on this. You can't expect a service to be provided to customers or to anyone for that matter. And if it's not utilized properly with common sense, if it's not utilized with the proper tools, and you don't use your personal judgment, whether it's right or wrong, that in itself can lead to some form of negligence on your part, not just the provider. So in this case, Google truly did their part. They provided the service. They provided the information. Now it was up to the end user to decide how they chose to use it. And whether the end user is familiar with that area or not, it doesn't give them the okay to say, well, you know what, they're not in the wrong when they chose to cross a 4-lane highway. She didn't have to use those directions. She could have asked, a passive buyer. She could have asked, someone in a store. She could have asked multiple people for an alternative way to getting to where she wanted to get to. That's like, you're in a kitchen and you're using a knife. It's sharp. Do you blame the people that created the knife? No, it's in your hands. You chose to use it. So in this scenario, I do believe Google, their outcome was just. I think the courts made a correct ruling, and I think overall it turned out well. I thank you, and this concludes my presentation.